My name is Greg Sim, and I'm a partner with a law firm called Field Law in Edmonton. And I focus my practice on professional regulation law, which of course the AIA is a professional regulatory organization. So I practice in the area of law dealing almost exclusively with professional regulatory organizations. And I also do a fair bit of labor and employment law and some civil litigation in and around professional regulatory organizations and labor and employment law. So it's always fun to get to come and talk about legal issues for members of professional regulatory organizations, because I feel like I know a little bit about that and hopefully can impart something useful to you by the end of the day. So when I was asked to come talk today, I was trying to think, well, what would be a useful topic to complement Peter and Tony's presentation about insurance for members of the AIA and any other professional regulatory organizations that may be represented here. And what I settled on was risk management. And the reason I settled on risk management is because when we look at risk management strategies, insurance, like we've been talking about, is one of the main things that we can identify as a strategy to manage those risks that are inherent in the practice of agrology and any other profession that you may represent. So it really is intended for this part of the talk to complement the presentation about insurance. Before we go into an examination of what is risk management and how would risk management be applied to our professional practices, to our business organizations, to ourselves if we're sole proprietorships, for example, it's useful to first talk about, okay, what is it that we're ultimately trying to avoid? And this is a talk about legal issues, so we're going to talk a little bit about legal liability as the ultimate thing we're trying to avoid with legal risk management. So there's three main types of liability I want to highlight for you. The first is regulatory or criminal liability. So that would be liability. Liability is not the exact right word for this, but it would be legal liability that arises in the context of, for example, criminal charges brought by the Crown, or liability that arises as a result of committing an offense under a regulatory statute. So those are the statutes administered by Sustainable Resource Development, the Alberta Energy Regulator, Utilities Commission, for example. Differentiate that from professional regulatory liability. And again, not the exact right word for it, but when I'm talking about professional regulatory liability, I'm talking about legal consequences arising from your relationship with your professional regulatory body. So for most of you, that would be the Alberta Institute of Agrologists. But if you're a biologist, it would be the Alberta Society of Professional Biologists, Forester, College of Professional Foresters, for example. Or there are several others as well. And then the third type of liability that can arise, and we've heard a little bit more about this from Tony and Peter so far, is civil liability. Right? So that would be disputes as between you or your business organization and somebody else. It might be in the employment context that I deal with, like wrongful dismissal actions. It might be a dispute arising between you and your employer if you breach a fiduciary obligation to the employer, if you go off and start your own business when the employer thinks you're doing their job, those kinds of issues. Those can give rise to civil liability. And then, of course, negligence, which Tony and Peter talked about in more detail. It's important to recognize that liability can arise for lots of different kinds of things. So things that happen in your private personal life can give rise to types of liability, like criminal law. Right? We'd all be familiar with the idea that if you do something contrary to the Criminal Code of Canada, you can be charged criminally, like getting a DUI or something heinous, for example. There's civil liability. So if you get in an accident with your vehicle and you hurt someone or damage some property, you could be civilly liable in your private life. Then there's things you can do in your professional life that might give rise to liability. So there's, we're going to look at this in a minute, but all kinds of offenses under the environmental statutes, like the Environmental Protection and Enhancement Act. If you're practicing and you do something, you could be held liable for committing an offense under one of those statutes, resulting in liability for you, your employer, or your organization. You might be found guilty of unprofessional conduct if you're a member of the Alberta Institute of Agrologists under the Agrology Profession Act, for example. We'll look at that again in a few minutes. But it's also important to recognize that although things that happen in your personal life can result in liability, and things that happen in your professional life can result in liability, there is a significant degree of overlap between those things that happens by virtue of the fact that you are members voluntarily of this profession. And I say voluntarily because, of course, no one compels you to be an agrologist. I realize you're probably thinking, well, I'm supposed to be a member of the Alberta Institute of Agrologists and I'm practicing. It's not optional. That's true. But these organizations, like the AIA and all the other ones, are voluntary in the sense that no one is forcing you to be a member of this profession. So by virtue of the fact that you are exposed to liability in overlapping types of ways. And let me give you an example of that. So I act for a variety of professional regulatory organizations. The AIA is one of them, but there are others. And I was recently involved in a case in the real estate industry. So what happened in this case was that a member of the real estate industry was out on his own time after hours at a bar. And it was not entirely clear, but we think he was socializing with some friends who some of them may have been clients of his. That part was a bit gray. But nevertheless, he drank quite a bit of alcohol. There was a receipt in evidence which showed how much alcohol they had consumed. He then got in his vehicle, made the extremely unfortunate choice to drive home, got into an accident, and killed someone. So of course he was charged criminally in his private personal life for that conduct, and he went to jail for almost 2 years. But right around the time he was up for parole and getting out of jail, the professional regulatory body found out about it, because they have a process, like most professional regulatory bodies, where your good character and reputation are something that they think about. And so if they receive information, and there's sometimes requirements to report these things that suggest your good character is in issue, they will assess, well, is that evidence of unprofessional conduct for a member of this profession? And so indeed they decided, this went before a discipline tribunal, and they decided that drunk driving and causing death for a member of this industry in this particular context was unprofessional conduct. And who knows whether in every profession it would be, right? But in this particular profession they decided that it was. Maybe it's because realtors drive people around in their cars a lot. But those are the kinds of things that you think about. Maybe it wouldn't be for a member of an environmental profession, but remember, a lot of you drive around a lot in company vehicles, right? So you never know. This kind of thing could happen. And that individual lost his ability to practice as a member of that profession permanently, right? So it's just an example of how things that happen in one context can result in liability in another context. Let's say we're sitting on a panel or a board or something, and I happen to be a PAG and the person sitting beside me is not. Do I have a higher standard of care for the types of things we're doing as a board? No, because unless it's the practice of agrology, you would not. But as a member of the public, you have an obligation to the AIA as a member. And so anything that happens in your conduct outside of work, on your own time, as a volunteer or otherwise, can be unprofessional conduct and can give rise to professional regulatory liability. So whenever you're doing things in your personal and private life, you need to understand that if you were not a member of the AIA, there'd be no one, except for maybe the police, who'd be interested in what you're doing. But because you're a member of this organization, the AIA is interested in what you're doing. And that's not to say that they're watching you, because they're not. But if it turns out that something bad happens, the AIA members are subject to your code of ethics and your standards of practice, right? And if something that you do in your personal and private life reflects poorly on the profession or harms the integrity of the profession, we would say, that can cause a finding of unprofessional conduct. And that can result in professional regulatory liability. Yeah, and we're going to look at the part of the definition of unprofessional conduct in a couple of slides, but it's a very broad definition. So it includes things like any lapse of skill or judgment in the practice of the profession. But it also includes things like any conduct that would harm the integrity of the profession. So that might be driving while intoxicated and harming someone. Or it might be, lying. in any context. It might be fraud. It might be anything like that that has nothing to do with agrology or the practice of agrology, but could harm the reputation of the profession in the eyes of the public as a whole. Okay, so what are the sources of criminal and regulatory liability that we want to think about? These are just some examples. There are obviously others that you could think of, like the statute that you mentioned, the Species at Risk Act. But the EPEA is one obvious example. The Water Act is another. The Criminal Code of Canada is a third, right? So those are the kinds of things that can result in obligations on you or me as members of the public, but can also result in, if we breach those obligations, conviction for offenses and liability. Okay, so here's an example of a section of the Environmental Protection and Enhancement Act, I'm going to butcher that, that creates an offense. So one of the things it says is that providing false or misleading information in any aspect of your professional life could be an offense, right? So if you were to submit a reclamation certificate application that turns out has false or misleading information in it, that could be a breach of the EPEA. Contravening the terms of a condition or an approval or a code of practice or a reclamation or remediation certificate, right? It's probably not too hard to think about how it's not that hard to go offside all the conditions that are on those things. But if you do, you could be committing an offense giving rise to liability. Enforcement or environmental protection orders. And then the last bullet, and this is important, Peter mentioned this discoverability for 2 years thing. So under this particular statute, every statute is different. What it says is that you can be charged with an offense from within 2 years of discoverability, which means 2 years from the date that somebody else could reasonably have discovered what you did. Right? Even if it's years and years after you did it, if you concealed it in some way, or if it was hidden, then they would say, well, we couldn't have discovered that until recently, and it's 2 years from the date that we actually figured it out. So there are a long period of time in which claims can be advanced. The 2-year limitation period that Peter mentioned for Alberta, that is for lawsuits. When you are a member of an organization like the AIA, you are exposed to complaints about your conduct for as long as you're a member. There is no limitation period. From the date that you cease to be a member and for 2 years after that, you can still be the subject of a complaint. So limitation periods are not that effective in defending us, and they're usually not high on the list of strategies to avoid risks. It's more of a, well, hopefully we'll have the benefit of that later, but we're not going to rely on it. What about penalties under regulatory or criminal liability? What kinds of hammers are out there that we need to be aware of? Well, under the EPEA, for example, the first and big one is fines. Fines are concerning because some insurance policies will provide coverage for fines, some will not. So even if you have insurance, it may not cover fines. That's something you want to think about and you want to look at when you're deciding which insurance policy are we getting. So for individuals, if you commit an offense under the EPEA, $50,000 would be the limit. It's not to say that every fine would be $50,000, but it could be up to that amount. And for corporations, $500,000. What about if they can prove that you did something knowingly? In other words, you knew that what you were doing was wrong, or you were reckless, and you ought to have realized what you were doing was wrong. Well, then it's a whole lot more. Up to $1 million for corporations, right? That's a lot of money to be payable all at once. Directors and officers?
Yeah.
Yes.
Okay.
Directors and officers, if they can show that the directors and officers of a corporation knew what was going on, there is a section in the EPEA, section 232, says that if a director or officer directed, authorized, assented to, acquiesced in, or participated in the offense, they can be guilty too. So it's very common to hear about, well, we'll just incorporate and then we'll be protected from liability. That is a principle of law, but these environmental regulation statutes are often designed to get around that protection. So they will say, if we can show that the directing mind of the corporation, the directors and officers, for example, knew what was going on, then they're personally liable as well. So that protection you get from having a corporation is not effective when we're talking about the public interest or the environment. Other kinds of things that can be imposed other than just fines and up to 2 years of imprisonment. Imprisonment, very rare, but can happen. Anecdote. I did a file for the dental profession recently we had a fellow who was not a dentist, but practicing in Alberta as a dentist. He was a dentist from Bolivia, but not registered to practice here. So we got an injunction against him. This would be under the Health Professions Act, so a bit different than the context we're talking about, but just interesting anecdote. So we got a court order that he was not allowed to purport to be a dentist or do dentistry, which is a restricted activity under the Health Professions Act. He breached that order and kept doing it. I had him put in jail for 5 days. 5 days in jail. And guess what? He's still doing it. So we're going back to court. So just an example. Very rare to put someone in jail for these kinds of things, but it can happen and it does happen. And insurance is not going to cover you while you're in jail. So the kinds of things that can result, criminal and regulatory liability, not just fines and imprisonment, but also injunctions, in other words, court orders that require you to do things or prohibit you from doing things, remediation orders that you have to do specific types of environmental remediation, publication. Everyone is going to know your name. You don't want that to happen. That's not going to be good for your professional reputation. Compliance bonds, community service, conditions, those kinds of things. This slide just talks about a few other things that can actually be ordered under the EPEA, so enforcement orders, shutdowns, reclamation certificate cancellations, etc. Those kinds of things that would be probably implicit in what we've been talking about. The last one on the slide is worth mentioning. So we're talking right now about criminal and regulatory types of liability, which usually means money, orders, potentially imprisonment. Traditionally, regulation has been very separate from civil litigation. And what I mean by that is that, let's say someone reports you to the police charge you with something and you're convicted of a crime, or you're convicted of an offense under a regulatory statute, you have to pay a fine or go to jail or something. That usually has not had any bearing on the ability of someone to sue you for the damages that they have suffered because of what you've done. So normally they'd have to sue you, go through a long, complicated, expensive litigation process. It might take years for that to resolve, if it ever does. And it's a very horrendous obligation for them to do, and so there's not a ton of it, right? But in some of these statutes, there is what's called a statutory cause of action, and it's like a shortcut. So if you are convicted of one of these offenses under one of these statutes, you can go to court. You don't have to prove the person is liable to you. All you have to show is the extent of your damages. Because you can say, by virtue of this statutory cause of action, their conviction under the EPEA is enough to prove they did something wrong and that I get money. The only question is how much money. Still complicated to work out, but a lot less complicated than it otherwise would be. What about the criminal side of things? Very brief example from the criminal side of things and how it might come up in the context of agrology practice. So the definition of fraud in the criminal code says that everyone commits fraud who intentionally alters, falsifies, or including omitting particulars from documents. So imagine for a minute that you work for an environmental company. And imagine you have a reclamation certificate application that you're working on, and imagine somebody who works for you, or maybe even you, omits some material detail from that reclamation certificate application. Then imagine that the certificate is granted. And then imagine that to do all this work, your company decides, well, we don't have enough money, we need to raise some money. So you go out and you do a private placement of shares to get some financing, to get some money. Then imagine that all goes through, the company's got all this cash, they're working away, and ultimately it's discovered that there was a material omission from one of those documents. And someone reports this to the Alberta Securities Commission, someone reports it to the police, and all of a sudden they're investigating and they decide that someone committed fraud. Right? So we don't often think of fraud arising from the environmental industry and these documents that are all prepared by all your companies and all your businesses, but that's just one example of how something that could result in regulatory liability or professional regulatory liability could also result in a criminal charge. Now let's switch gears a little bit and talk about specifically professional regulatory liability. And what do I mean by that? Well, I mean liability because you're a member of the Alberta Institute of Agrologists or one of the other professions. So the sources of that, the main sources would be the Agrology Profession Act, the Agrology Profession Regulation, the Code of Ethics, the Standards of Practice, and any joint practice standards that are out there that guide you. So for example, there's one about reclamation and remediation in the oil and gas industry, and I think there's one that we're working on for wetlands as well. Right? Probably you're more familiar with those than I am. Those are the sources, the main ones anyway, of liability as a member of the profession. Now what do we mean when we say liability specifically? Well, there is a definition, but it's an extremely broad definition. Here is part of it. It's a really long laundry list of things that can be unprofessional conduct. So the first one, I mentioned this before, is a lack of knowledge, skill, or judgment in the provision of professional services. So that's where we'd say, did you live up to the expected standard from a person with your qualifications and your experience who's a member of this institute? We'd compare you to that standard and decide, was your conduct unprofessional or not? But there's a whole lot of other things as well. So contravening the Act, contravening the Code of Ethics, contravening the Standards of Practice, those would all be unprofessional conduct as well. Contravening any other enactment that applies to the profession. So that would be the EPEA, the Water Act, Species at Risk Act, probably lots of others, privacy statutes, the Personal Information Protection Act, for example. All those things, in the right context, could be unprofessional conduct and give rise to liability as a member of the profession. What about holding yourself out as a member while you are not a member? If you're suspended or cancelled, for example, you're not allowed to use the PAG title. That would be unprofessional conduct. What about refusing to comply with a continuing competence program? We all know that you have continuing competence obligations. That's why you're here, right? Right? It's not because I'm so fascinating. But if you were to fail to comply with the required number of credits and the program requires, and they audit you, which they will do at some point eventually, that would be unprofessional conduct. Contravening an order or a condition on your practice permit. So you'll probably be familiar with the process when you renew as a member of the AIA. They review what you're doing, they review your qualifications. It's possible that they would say, we are going to impose a limitation of some kind on what you can and can't do. If you were to breach that and they found out, that would be unprofessional conduct. It's unprofessional conduct whether they find out or not. But you could be charged with it if they find out. The point of this part of the talk is that anything that you do as a PAG or an RTAG or a member in training of this organization could give rise to professional regulatory liability if you're, breaching something under a federal statute, a provincial statute, as long as those are reasonably connected to the practice of your profession, whether you're in Alberta, whether you happen to be in Saskatchewan that day, whether you're on reserve lands, whether you're on federal lands, provincial lands, private lands, except, well, there's this one little thing that says you're not required to be a member if you're on lands that you own an interest in, but that's a bit of a different issue, and it's whether you're required to be a member or not. Not whether you already are a member and then doing something unprofessional. So that's the definition of unprofessional conduct as a member of the AIA. What about the hammers? We looked at the hammers under the EPEA, for example. What about the hammers under the Agrology Profession Act? What kinds of consequences are we looking at if we are found to be liable in the professional regulatory context? Well, there's cautions. Those are like warnings. There's reprimands. Those are like written punitive sanctions that go on your record forever. There are conditions that can be imposed, so you can't do a certain area of practice, or you have to do a certain area of practice, or you'll be suspended until you've done something to show that you're competent. There are courses or experience requirements that can be imposed on you. They can suspend you, and if you're suspended, you have to stop practicing as long as you're suspended. You can be canceled. That would be the ultimate one. It'd be very rare, but still it's possible. You may be ordered to refund any professional fees you earned in an engagement. You can be ordered to pay the costs of an investigation and hearing. Let me digress for a second to tell you about another thing that I did recently. Dental profession again. This time the person was a member of the dental profession. Extremely long, complicated investigation covering many years, 7 years I think. 4-day hearing. Legal costs of the investigation and the hearing, $280,000. And so on Friday last week, I signed a document making a submission to the hearing tribunal for that profession saying we thought he should pay 3/4 of $280,000 because he was found guilty of unprofessional conduct. So the potential is extremely significant. And one of the things you want to be looking at when you're looking at these insurance policies is, am I covered? If so, for what? Am I covered for negligence damages? Am I covered for professional regulatory liability? Am I covered for costs of my legal defense for a civil lawsuit or a professional regulatory complaint? Am I covered for costs? These are all really important questions to ask. The Alberta Institute of Agrologists does not regulate practice entities, they regulate individuals. So some professions regulate practice entities, like corporations. For example, engineering corporations have to have a permit, and the individual professionals also have to be members of the organization. That is not currently the case in this profession. Okay, so that is an introduction to what are we talking about when we say a liability, because we're talking about risk management and we want to understand what is the ultimate risk we're trying to manage. The ultimate risk we're trying to manage is legal liability. How do we do that? Risk management. And that brings me to really the focus of the talk today, risk management of legal liability. So when we talk about risk management, what do we mean? Probably a lot of you have heard about risk management before. Probably a lot of you have done strategic planning and risk management planning. But we're going to talk about it a little bit today because it's really useful to set up a discussion of how we can avoid legal risks. So there's many definitions of risk management. This one is a bit cobbled together from some things I've read in the literature, but risk management for our purposes today is the identification, assessment, analysis, avoidance, reduction, sharing, and retention of risks. So let's do a risk management analysis. We're not going to do a deep dive into any one aspect of the risk management process today, but we are going to look overall at the ideas that exist behind risk management. And what I want to do is to give you a list of some practical techniques that you can actually take away and start implementing in your own practices and your own projects when you get back from this conference. So risk management can be defined in different ways. Some literature defines it as a very straightforward, simple, sit down, think about what are all the risks we want to avoid, how are we going to avoid them. Other definitions, a lot more sophisticated, a lot more steps, and a lot more analysis involved. This is somewhere in between. So what is risk management? What does it involve? First, it involves an identification of risks. So what circumstances or events are we concerned about that could give rise to liability? Yes?
How do you define risk?
How do you define risk? Well, I would define it, so for this context and from the literature I've read, I would define it as a threat that could result in liability. And when I'm talking about liability here, I'm talking about financial liability, imprisonment, a significant risk to the reputation of my practice, my profession, my organization, those kinds of things. Risk management is a whole lot broader than what we're going to talk about today. So, I mean, you're probably familiar, there's business continuity risk management, there's reputational risk management, all kinds of things that are way broader than we're going to talk about. So, identifying risks is step one. Step two is assessing our vulnerability to those specific risks. So, where do we have weaknesses in our processes that give rise to those risks? So, as an example, one of the things that my firm and my practice group have been doing recently is going into one of our clients' organizations and looking at everything they're doing. Now, these are regulatory organizations, so it's a little bit different than your businesses. But by going in and looking at everything we're doing, from an outsider's perspective, we're identifying where are their vulnerabilities, right? Where are things that you're doing exposing you to legal risks? And then we make recommendations to close those gaps. What about risk determination? That would be number three. So risk determination, from what I've seen, is defined as what is the expected likelihood and potential consequences of specific risks materializing. Now, we're not going to look at that in a lot of detail today because that's really mathy, and I'm not a mathy type of person. Okay? But there are obviously professionals out there who are really good at estimating probabilities, like statisticians and actuaries and things, and they can help you with that kind of analysis. Number four is the identification of risk management measures. So what can we do once we've identified risks to try to manage those risks? And we are going to look at some practical takeaways today. Now, they're going to be really simple things that you've probably thought of, at least some of them before. But my hope is that by giving them to you, you'll maybe be able to use some of them. And maybe by listening to them, you'll think of something else that you might implement in your own practices or your own businesses. And then lastly, strategic prioritization of risk management measures. In other words, how can we most effectively implement these risk management strategies according to the limited resources that we have available to us right now? Because we recognize that you can't manage all risks to the point where they are at zero. Right? That would cost way too much, and it might not even be possible. What about this identification of risks? How do we do that? In any risk management process, you need to start with a list of the risks that we want to manage. So in my list review, I saw that in simple risk management processes, it was suggested to just sit down and brainstorm them. Well, that is one way to do it, and that might be effective for some of our practices or our organizations. But in some of the other literature that I was looking at, the concern was if you only approach risk identification in one way, you're going to miss things. And so you have to approach it in more than one way. You have to try to think of what are some other ways we could approach risk identification so we can think about things from different perspectives and get all of it. So one example is source analysis, where you sit down and you think about what are all the sources of a risk, for our purposes today, that could give rise to legal liability. And another example would be problem analysis. What are the problems that might arise in our industry that could give rise to legal liability for us? If you do that, you'll probably get a whole lot better list. So what about source analysis? Well, here's a sample source analysis that might start you off in your industry. So what are the sources of a risk? Legislative branch of the government. Somebody might create a new statute. The statute might have new obligations to comply with. There might be breaches resulting in offenses, resulting in liability. What about the executive branch? They might enact a new regulation. The regulation might create a new obligation. There might be an offense for breach of the regulation. That might give rise to liability. What about regulatory bodies? What about a new standard of practice? What if the AIA imposes a new code of ethics provision? That might create an obligation. That could give rise to liability if I don't comply with it. Stakeholders. What about members of the public who are interested, like public interest groups? What if they become very interested in an issue, start raising concerns about it, make complaints to regulatory bodies, professional regulatory bodies, or the police? Right? That can give rise to liability. Clients. Any dissatisfied client is a source of problems, right? Because they will complain about things. You don't want that to happen. They might sue you. You don't want that to happen either. Employers, similarly, they might raise concerns with what's going on. They might have all kinds of claims against you. If you don't provide them with reasonable notice, if you leave an employer, that could be a claim. If you start a different business while you're working for someone, that could be a claim by an employer.